Hello, everyone, and welcome to Uncivil Law, where we gain legal knowledge through the misfortunes of others. If you're enjoying our content, please remember to subscribe and hit the notification bell to get notifications of all of our uploads. For today's case, we're dealing with a class action in which the lawyers were trying to benefit themselves, and the Court of Appeals is having no part of it and having a little fun along the way. This is the case of Robert Brazzino versus M. Todd Henderson and Conagra Foods. In this case, there was a lawsuit over some product labeling, and there was a proposed settlement. And the proposed settlement had the aspect of really benefiting the lawyers more than really anyone else. And one person objected. One brave person objected. And the Court of Appeals is looking over this and being like, no, that settlement is really not fair. And they're having some fun along the way, beating up both the trial court and beating up the parties. So we're going to read this decision, read a little bit about what's going on. Let's get started with this. We can perhaps sum up this case as how to lose a class action settlement in 10 ways. The parties crammed into their settlement agreement a bevy of questionable provisions that reeks of collusion at the expense of class members. Class counsel will receive 7 times more money than the class members. An injunction touted by experts as worth millions of dollars is apparently worthless. The defense agrees not to challenge the plaintiff's attorney's fees. Any reduction in those fees by the court reverts to the defendant instead of having to be paid out by the defendant, and on and on. While courts should not casually second-guess class action settlements brokered by the parties, they should not greenlight them either, just because the parties profess that the dubious deal is all right. We reverse the district court's approval of the class settlement because the agreement raises a squadron of red flags billowing in the wind and begging for further review. So we're off to a very promising start. So we got this class action settlement between the parties. The parties are happy. And the Court of Appeals is, just because you guys say it's okay, maybe not so much. There's a couple red flags. Maybe we should take another look at this. So what are those red flags? Let's learn a little bit more. For many years, ConAgra, the then owner of Wesson Oil, the cooking oil, labeled their product as 100% natural. In 2011, Robert Brazzino and others sued ConAgra, alleging that the 100% natural label is misleading because Wesson Oil contains ingredients from GMOs. So this guy wants to sue for the product labeling because they label their product as 100% natural, but the oil actually is made from GMOs. And so he wants to sue over that. Okay. 3 years later, the plaintiffs sought a class action certification. Relying on their expert, Mr. Ware, they argued that they overpaid for their oil based on the 100% natural. Because, all right, so we want to bring a class action lawsuit for deceptive labeling, and we want to argue that we overpaid for our cooking oil because it was labeled as 100% natural, and we didn't think that that meant GMOs. And if we'd known, we would have paid less. And we're upset about paying too much for our cooking oil. And we want to bring a class action over that. All right, so let's do that then. Enlisting its own expert, ConAgra, owners of the oil, asserted that price data showed the label did not affect the price of the oil, which I believe. According to ConAgra, if the public had cared about the label, the price of the oil should have declined after they removed the label, but no. Okay, so the district court agreed, denying the first certification request. So not so much for your class action, but that's okay. We're going to give it another go. Still hoping to strike oil, and definitely pun intended, from the Court of Appeals here, the plaintiffs filed an amended motion. This time, however, they supported their expert with another supporting opinion from Dr. Howlett. Together, the plaintiff's experts assert that consumers paid 2.28% too much for the oil. Okay. The expert suggested that a conjoint analysis could help determine how consumers value the oil, but they never actually submitted it. So they think they overpaid to the tune of 2%. Okay. Meanwhile, ConAgra decided to sell the Wesson Oil brand. They tried Smucker's, and in doing so, they voluntarily removed the label and stopped marketing it this way as natural. ConAgra maintains that the litigation played no role in the decision to sell it, which I definitely believe, and no part of the decision to remove the label, which I'm also inclined to believe. For some reason, the deal fell through with Smucker's. Undeterred, ConAgra sought a new suitor. At the same time, it engages in mediation for this class. And then they propose a settlement agreement over the cooking oil. And in substantive part, they propose the following settlement. 15 cents, which does sound roughly like 2%, 15 cents for each unit of the oil purchased to households submitting valid claims up to a maximum of 30 units. And an additional fund of some other things and some other things. So 15 cents per purchase basically is the bottom line on that one. That's the massive amount that maybe we oversold you on somehow, but that's what they propose. Okay. With a class of nearly 15 million consumers, because that's how many people bought Wesson cooking oil, which I also believe, ConAgra claimed that it theoretically exposed itself to $57.5 million in claims if every consumer submitted a claim. Because every consumer could submit 30 claims, right? So if 15 million consumers had submitted 30 claims each, hey, we're exposing ourselves to $57.5 million of liability. But the court notes that that never happens, not even close. The settlement agreement established a fund on claims made basis. So the fund is based on how many claims are in fact made. ConAgra would pay out only for claims made. The settlement did not require ConAgra to identify or provide direct notice. I'm not sure necessarily how ConAgra would identify its consumers of its products. I'm not sure how it would do that or provide direct notice, but they didn't even have to try. The settlement agreement also provides for injunctive relief should ConAgra have seller's remorse and decide that they don't want to sell the product Wesson Oil anymore, because remember, they've been trying to sell this brand for a little bit now. Unless the FDA permits the use of the term, they can't use it anymore. So they agree to no longer do that. And Mr. Ware said that the value of this injunctive relief is $27 million. So because ConAgra has agreed that if it decides, we don't really want to sell the Wesson Oil brand anymore, but we can't do this. And our agreeing to do this is worth $27 million. Okay. All right. The settlement also stated, and perhaps more importantly, ConAgra does not contest that the attorneys get $6.85 million. Now, I'd like to take note here. The attorneys is in no way tied to the amount of consumers who get a claim. Actually, now I think about it, that would be a wonderful way to deal with these class action things. We make the attorney's compensation directly tied to how many consumers actually get compensation. I'm not sure how you would actually work that out formulaically, but that'd be interesting. So the idea would be the attorneys have a very strong incentive to get more people to claim it, which is, after all, the people they're trying to represent in the first place. Technically, they are their clients, right? All 15 million of these people are technically their clients. That's a class action. So the attorneys, in a very technical sense, represent all these people. So as fiduciaries, they should have an interest in getting them paid. So they should perhaps have the class action settlement tied to that. But it's not. They get $6.85 million no matter what happens. All right. So, yeah. So the parties thus represent the settlement could theoretically be worth $100 million. $95 million of value to the class, because $67.5 million in our 15-cent remitters, plus $27 million worth of injunctive value, and $6 million of attorneys. So we've agreed to $100 million of payout. But, not so much, because ConAgra actually shelled out only $8 million, with only $1 million actually going to the class. So how many people actually... So $67.5 million worth of claims could have been made, but only $1 million worth of claims were made. for the 15 cents at a time. Class counsel fees swallowed $5.85 million and expenses devoured about $1 million. Of the 15 million members, barely more than 1/2 of 1% pursued a claim for their 15 cents. So not so much with the liability. And then one class member objects. One of the 15 million objects, hero to the cause, Mr. Todd Henderson. He is the hero to the cause, the hero that we perhaps do not deserve, but definitely the hero we need. A law professor at the University of Chicago objects to this settlement under the rules, arguing that the attorneys got paid 88% of the actual damages. So maybe this is not so great for the class, maybe better for the attorneys, and that might be a problem. This guy asserts that our precedent requires the court to treat the settlement as a constructive common fund. The settlement effectively establishes one fund to pay out to both the class members and their counsel. Henderson also contends that the settlement's clear sailing provision, which is the provision that ConAgra refuses to challenge the agreed upon amounts, right? So we don't care about that. And the kicker clause, any reduction in fees revert to ConAgra, not to the class members. So anything that isn't claimed goes back to ConAgra, which is the reverter, right? It raises the specter of collusion. He also objects to the stipulated value of the injunction. He describes it as illusory. So they might say it's worth $27 million, but I say it's worth about $0. And Henderson also castigated one of these experts because of their stuff too. Okay. So plaintiffs are on appeal, seeking final approval of the settlement. Based on the declaration from one of the witnesses in the case, they valued the label change at $19 million. So ConAgra says this is $19 million worth of value. They also contend that if Wesson's new owner, Richardson, continues from refraining the product as natural for even a year, the value would surge to $30.2 million. So an additional year's worth of this labeling is worth $11 million. And for every year that is not labeled, the class would obtain a benefit of $11 million. All right, so with the claim deadline passed, class members made 97,000 claims for $418,000. So 97,000 people wrote in for their 15 cents apiece, times 30, for a collective $418,000, which is, decidedly less than $67.5 million theoretically. One might even say it's a rounding error away from zero compared to that. Even separately funded pools for New York and Oregon, ConAgra would pay class members, because also the states get a little bit of money here. They pay the class members a maximum of $990,000. Out of a class member of 15 million, fewer than 100,000 would receive even a single penalty. So the class, maybe this is less about the class and more about the lawyers involved. Okay. The district court went on to evaluate the settlement for fairness under the relevant law. The district court explained that the length and nature of the suit allowed both sides to evaluate the costs and benefits of the litigation, supplemented by a recommendation of a court-appointed mediator. The court's concerns over merits of a plaintiff suit heavily influenced the analysis. The court, relying on a lodestar method, which you don't really need to know what that is, but it's just a method of trying to calculate what attorney's time is worth. So it's just a method of counting for it, okay? They found that the class counsel's $6.85 million reasonable given the amount of the lodestar. Indeed, the court appeared impressed. Defendant was willing to pay anything at all, given the defendant's many liabilities and damage issues the case had from the beginning. The court also pointed out the amount of hours reasonable spent on the litigation, counsel's effort in litigation, and the results achieved and the risk inherent. So the court thought that this was great because he thought the plaintiff's case kind of sucked from the very beginning, right? So he's kind of impressed. The defendants agreed to pay anything. Wow, these must be great attorneys. They must be great because this case kind of sucks, but they're willing to pay out. So, hey, they must be doing a great job. The district court also emphasized the substantial nature of the 15 cent per unit award. Substantial. Given that it had restricted relief to only the portion of the premium attributable to consumers' belief that 100% natural meant GMO free. It concluded the settlement amount offered provided an immediate and tangible benefit to the class, and eliminated the risk that they could receive less than an amount, heaven forbid, less than 15 cents, or nothing at all, which, I'd contend 15 cents is pretty close to nothing at all, but who am I to say that, right? And while the court appreciated this random objector law professor's guy high-level concerns regarding the apparent trend toward class action settlements disproportionately benefiting attorneys, the district court was not persuaded that the attorney fee rendered the entire settlement unfair. So the district court had no problem with that. And Henderson, here to the cause, decides to appeal. So the one guy is trying to put a damper in this class. Now, there are many situations, and we've seen them, and the rules have been changed to discourage them strongly, because there are some people who object to the class merely because they personally want to benefit. But that doesn't seem to be the case here, because how much could this one guy personally benefit anyway? But yeah, he's standing up for the cause and being like, the entire class he's a law professor, he's doing it for fun. Which, hey, why not? It's a great case study, so sure, why not? It's worth my time. So he's appealing. So the Court of Appeals wants to review this for abuse of discretion, which is a pretty hard trigger to pull. So we're going to review this if the district court abused discretion. All right, let's figure out the judge did that. The Court of Appeals will rarely overturn an approval of a compromise settlement unless the terms of the agreement contain convincing indications that self-interest rather than class interest in fact influence the outcome. So we have to look for signs that the settlement was not in the interest of the class, but perhaps was in the interest of those negotiating for it. Let's look for those symbols, see if we can find them. The relevant rule imposes on the district court an independent obligation to ensure any class action settlement is fair, reasonable, and adequate, accounting for the interests of absent class members. We therefore recognize an independent obligation to ensure any attorney's fees, like the settlement itself, is reasonable, even if the parties have agreed to it. Settlement agreements warrant special attention when the record suggests the settlement is driven by fees when counsel receives a disproportionate distribution. So if the attorneys are getting a disproportionate amount, that is suggestive that, maybe it's really about the attorneys and not so much the class. We have recognized the risk in allowing counsel to bargain on behalf of an entire class, especially in a pre-certification challenge when counsel might strike a quick settlement. So we are going to now talk about two different stages of when we could be talking about settlement, right? So we could be talking about settlement prior to class certification or after that point. So we have definitely taken notice of these pre-certification challenges when maybe we're just out to get a quick settlement and a quick buck. And we've been really, really concerned about that in the past. And that's not our current situation because the class was certified. So we have to talk about those two things at least differently for the moment, right? So in a case called Bluetooth, which I don't know if that has anything to do with the technology or not, but it's called Bluetooth. In a case called Bluetooth, we explain that courts should scrutinize agreements in pre-certification challenges for subtle signs the class has allowed, for subtle signs the attorneys have allowed the pursuit of their interest to infect the negotiations. Here's some potential indications. If the attorneys receive a disproportionate distribution, if the parties negotiate a clear sailing agreement, and if the agreement contains a kicker or reverter. Hey, that's interesting because this agreement contains all three of those signs. In reviewing settlements struck before the class certification, district courts must apply these so-called Bluetooth factors to smoke out potential collusion. So before certification, we've said these three things are really suspicious. Counsel's going to get an undue amount. It contains we're not going to contest the attorney's fees clause, and it contains hey, you get back any money that's not claimed clause. All right? So that was pre-certification challenges. However, left open was the issue about, hey, how about post-certification challenges? Which is a reasonable thing. How about that? Well, the answer in part flows from a revised rule. The rule has changed. In December 2018, Congress and the Supreme Court has amended the rule to help determine what is fair and reasonable. Because before, it didn't say. It just said, determine what's fair and reasonable, and then didn't go on to any additional details. Now there's some additional details. We went and provided some additional stuff. And 2 of those details look like they might be on point. The effectiveness of any proposed method of distributing relief to the class, and the terms of any proposed award of the attorney's fees. Under the revised rule, district courts must consider the terms of any proposal of the attorney's fees when determining if the relief provided is adequate. When none of the sister circuits have directly addressed what this specifically requires, because it's not specific, it's a factor, the plain language indicates a court must examine whether the attorney's fees arranged shortchanged the class. Did the attorney's fees, in and of themselves, shortchange the class? Okay? Nothing in the rule suggests the requirement applies only to a pre-certification challenge. Congress has required the courts to scrutinize attorney's fees even if the settlement occurs after class certification or for any other time. And the court goes on for good reason. The specter of collusion casts a shadow over post-certification too, when they involve divvying up funds between a class member and the class counsel. We have observed that courts should scrutinize pre-class certification because plaintiff counsel may collude with defendant to strike a quick settlement without devoting substantial resources. So in a pre-class certification, counsel might want to just do a, quick and dirty lawsuit. Everyone gets paid, everyone goes home, right? No one really invests a lot of energy. So it's just a quick in and out, right? On a pre-class certification. So that is the problem pre-class. In contrast, it has been suggested that by the time a court has certified the class, or so the theory goes, the parties have vigorously litigated the dispute, reducing the chance that class will settle on a quick settlement, right? So by the time you get to a class certification, which requires some effort, it does, right? You've put some energy into this. And so because you've devoted substantial time and resources, fair, class counsel has some skin in the game, which guarantees their interest in maximizing the size of the settlement fund. Or does it? It might guarantee the interest in maximizing something. Not so sure about that being the settlement fund. Likewise, because the district court has appointed class counsel who owes a fiduciary duty to the class, because again, the class has been certified, and they all are. The entire class is their client, all 15 million of them. So that means they have a fiduciary duty, right? So therefore, class counsel would be ethically forbidden from sacrificing its class members' interest because it does have a duty. The same as if it had one person, right? If you have one client or 15 million, you have a duty to the client. Now, the duty is slightly different in the case of 15 million, obviously, but let's say the execution of the duty is different, but the nature of the duty is the same. So surely the attorneys wouldn't look to, benefiting themselves because they have a fiduciary interest in protecting the entire class, who was, after all, their clients. So all that might be true, but somewhat beside the point. Class certification does not cleanse all sins, especially when it might involve collusion over divvying the funds between the counsel and the class. Because the counsel might be tempted by the $6.85 million, even if that is a perfectly reasonable attorney fee, which maybe it is, right? No one at this point, and let's not even get into whether it's a reasonable attorney fee. Maybe it is, because certifying a class is some work. Maybe it's a reasonable fee, maybe not. I don't know. We could get into it. I don't really care for the moment, whether it's reasonable or not. Maybe it is. But maybe they'd be somewhat inclined to agree to it if they're being offered it, right? So maybe $6 million is reasonable. And if they say, well, maybe they'd agree to it just if we give them the $6 million, because, hey, they're happy, right? Yeah. Even after a court has certified a class counsel still has an incentive to conspire with the defendant to reduce compensation for the class member in exchange for a larger fee. A defendant will go along with this because it doesn't care, because why would it? The defendant doesn't care. The defendant only cares about total payout. Right. The defendant really only cares about how big a check it has to write. Does it really care where the money goes after that? Not really. It's the same check either way. So if no matter if the class has been certified or not, no matter if the class gets paid or not, They have no reason to care because its incentives are all about its bottom line, which it is. And that's really all it should care about. I'm not blaming ConAgra over here. ConAgra is acting perfectly rationally. They are. They want to reduce their liability. Now, whether or not they should fight it or not, is up to them. But they're like, we don't care. We can settle this out, whatever. It's up to them. And their incentives are perfectly fine. And do they care if the attorney gets $1 or not? Not really. Do they care if the client gets $1? Not really. All they care about is how much money is it going to cost them. And the court just then illustrates an example. What would any rational person do if they're faced with these two options? Okay, you're a defendant. You have two options. Would you either, one, establish a $10 million fund for class members and pay $3 million in fees to the class for a total payout of $13 million? Or would you instead set up a $7 million fund and pay $4 million for a class for a total payout of $11 million? Well, the court thinks, and I think probably right, the defendant would choose the second option because it's $11 million versus $13 million, even though it shortchanged the class. Nothing about the class certification can make them care more about its own bottom line. They're not the class is not their client. They're their customers, but not their client. So, there's that. Put another way, post-class certification ensures only the parties litigate aggressively to reach the total size. It does not, however, address the inherent incentives that might tempt a class counsel to elevate his own interests above those of the class. Not that happened here, of course. As one prominent academic who supports class action put it, the profit motive will give a class action lawyer incentives to do sneaky things. No. Profit corrupting? Surely not. Surely when it's $6.85 million, there's no reason the attorney might potentially be somewhat jaded in its conclusions. The potential for collusion is not a hoax. Therefore, Congress ought to end this practice. We thus therefore hold that you must apply these factors to post-class certification in addressing where division of funds is adequate. So, apparently Congress noticed a problem, and Congress went and tried to fix it. And the Court of Appeals is here to help. It's like, maybe take notice of the attorney's fees as part of this. And try to say, when they reached this deal, were they trying to benefit themselves? Of course they are. And an attorney trying to benefit themselves is perfectly fine. In fact, it's one of the very reasons that we create class actions in the first place, right? It's basically a bounty. It's a big ass bounty program, right? We are deliberately somewhat trying to create incentives for the attorney to enrich themselves. It's kind of part of the goal, actually, because we're assuming their greed will take over. And then they will, want to do things that will help. How can I get this $6 million? I'm so glad you asked, right? And Congress said, hey, wait a second. We provided some incentives, but we didn't really do greatly enough on the controls to make sure that we were getting out the other half of the equation, right? We said, hey, here's a big pile of money. And the attorneys went, yay, money. And maybe we didn't do quite as good on making sure that we're getting the other half of what we're giving the money for. Right? The other half of this contract. Maybe we should try to balance that out a little bit more. And the Court of Appeals says, you got to take a look at that because Congress noticed the problem and they actually fixed it. It's nice, I know, right? So let's do that. Perhaps because the Court of Appeal had not clarified whether the factors applied to post-class, the district court didn't scrutinize this. Fair enough. The district court, and there's a lot of reasons the district court might reach this conclusion. The rule has changed, but then again, the district court is influenced, as it should and must be, by the precedent, which of course is precedent under the old rule. So the court could deviate, but still, it's the old rule, right? So did the district court screw this up? You can decide for yourselves if the district court screwed this up or not. But the Court of Appeals is like, maybe the district court did this because, they came to wrong conclusions, but, that's okay. We'll give them another shot. So this lodestar amount thing that you used can now alone tell us if fees are reasonable. Counsel may have frittered the hours away on pointless motions or pointless discovery, padding the lodestar, right? So the lodestar is the calculation of the attorney's fees. And the attorney's fees are based on, amount of hours worked, as you'd expect. But the Court of Appeals notes, hey, wait a second. Maybe it's possible that the attorneys padded their hours. I know. Maybe an attorney padded their hours. Such a thing has never been heard of or contemplated before. Maybe maybe the attorney filed some motions or some things that weren't strictly speaking necessary and only did it in order to pad their hours so that they could pad their fees. Heaven forbid, but maybe it's possible. So Lodestar thing alone maybe not is enough. Maybe counsel devoted tremendous hours but achieved very little for its class. In any event, attorney's fees based on a percentage of unreasonable hours is still unreasonable. Plaintiff's counsel received a disproportionate distribution of the settlement. The lion's share of the money, almost $7 million, will end up in the pockets of the attorneys, while the class receives relative scraps, less than $1 million, at 15 cents apiece, one would note. So little goes to the class members in a claims-made settlement such as this one because the redemption rate is notoriously low when it resolves small tickets. I know. I mean, 15 cents times 30. What is 15 cents times 30? $4.50. So how many people are really going to go for the $4.50? How much time is it worth? Apparently the answer was about 500,000, so still, but yeah. The redemption rate sinks even further if the settlement provides no direct notice to the class. Despite ConAgra's claim that it hypothetically had $95 million of liability, which it did, on some paper somewhere, yeah, it had $95 million of liability, but everyone knows no and no. And no surprise, considering how the parties structured the settlement, intentionally or otherwise, of course. The gross disparity in the distribution of funds is a red flag demanding more attention and scrutiny. So, hypothetically, $100 million. In reality, $7 million, and $6 million of it is going to the attorneys. Finally, the agreement contains a kicker or reverter clause in which ConAgra, not the class, receives remaining funds if the court reduces the agreed upon fees. We have identified this too in Bluetooth as a warning sign. The reason is obvious. If ConAgra is content to pay $7 million in class counsel fees, but the court finds the amount unreasonable, there's no plausible reason why the class should not benefit from the spillover. All right. So this is how deep it goes, right? There's two clauses. There's two clauses in this thing just to make things interesting. First, you agree not to contest the attorney's fees, which doesn't preclude the court from looking at them separately, because the court is supposed to look at them, right? So just because the other party doesn't object doesn't mean that the court can't say no, right? So first of all, you agree not to object. But second of all, you agree that if for any reason the fees get reduced, we're going to get the money back, not the attorneys. And the attorneys also agreed to that, right? So if, heaven forbid, the trial court finds that these attorney fees are unreasonable, we're going to get the difference, not the class, right? And there's no reason like the class shouldn't get the money, but they're not going to. As we've warned in our prior case, Bluetooth, unless the district court is able to conclude that in this particular case, a kicker provision is in the class best interest, which maybe it is in some situation. Maybe that is in the class best interest. It could be, because it does increase the exposure for the attorneys a little bit. The kicker makes it less likely a settlement can be approved if the district court determines clear sailing, because there's not going to be an objection. Okay, so far we've been talking about those hard dollar bills, y'all. You know, the dollar bills, the checks, the things that have actual numbers to them. And we've determined that the $8 million, I think I said 7 earlier and I misspoke, $8 million of 7 going to the attorneys, that's hard money. That's actual dollars, right? But there's another thing here that's not money. There's this injunction, remember? Because they agreed to not label their products 100% natural anymore unless the FDA says it's okay with GMOs, right? So, hey, we agreed to that, and that's worth some money, right? And the class is getting a benefit because we're not going to deceptively label our products anymore. So the class is being benefited because they won't be cheated out of that 15 cents anymore. All right, let's figure out if that's worth anything. So Henderson says the district court failed to recognize the injunction is worthless, right? Because the district court says this injunction is worth something. And our hero, the law professor, says, actually, no, it's worth nothing. So rather than attempt to quantify the value of the relief, instead concluded it had some value. The district court didn't even conclude how much value it is. Remember, ConAgra came up with a number. I don't even remember what it is, and it doesn't matter right now. ConAgra came up with a number. The district court didn't even come up with a number. They just said it has some value. And the court says no, not even that. So that's reversible. It had no value. We go further and hold the district court erred by placing even some value because it is and was virtually worthless. No. A district court abuses its discretion when it approves a settlement despite no evidence the relief afforded has any value. Yet to obtain it, they had to relinquish the right to seek damages in another class. So the Court of Appeals is like, it's worth nothing. Critically, we find illusory any injunction that does not obligate the bound party to do anything it was not already doing voluntarily. So if you were already doing it, bounding yourself to do it, yeah. Not because of any court-imposed settlement, when a defendant would therefore be unlikely to revert back previously. So if you are doing a thing voluntarily and then you're like, oh no, we'll bind ourselves to continue doing that thing, unless there was some chance of you not doing that thing, then, All right, so ConAgra over here agreed to refrain from marketing Wesson oil as 100% natural. That sounds great and all, except ConAgra had already abandoned that strategy in 2017, 2 years before the parties hammered out the agreement for reasons unrelated to this or any other litigation. And then here's the real kicker. Even worse, ConAgra's promise not to use the phrase 100% natural on Wesson oil appears meaningless because ConAgra no longer owns Wesson oil. They sold it. They succeeded. They sold it. So they have agreed to not label a product that they no longer have the ability to label. And this is where the court has a little fun. In reality, this promise is about as meaningful and enduring as a proposal in the final rose ceremony on The Bachelor. Ouch. Simply put, Richardson, the new owner of Wesson Oil, can resume using 100% natural at any time it wants, because they're not ConAgra, thereby depriving the class of any value theoretically afforded. ConAgra thus agreed to not do something over which it can't do. And then this is really nice little kicker here. That is like George Lucas promising no more mediocre and schlocky Star Wars sequels shortly after selling the franchise to Disney. Such a promise would be illusory, and then the district court has a footnote as evidenced by Disney's production of Last Jedi and The Rise of Skywalker. So the Court of Appeals is saying ConAgra's promise is a lot like George Lucas saying there will be no more bad Star Wars movies after he no longer has the ability to control it. And we know that theoretical promise would be illusory because, in fact, Disney produced Last Jedi and Rise of Skywalker, which are crap. So Last Jedi and Rise of Skywalker has, in fact, been determined by a court of appeals to be shit. So that is a legal finding, just in case you wanted to know. Yeah. We do not question the district court's view of the plan's likelihood of success in future litigation, which, yeah, because they didn't really have success the first time around, but there's a whole other set of problems. But even if the class gave up very little, it has the right to receive something in exchange. And they didn't because the injunction is worthless. Mr. Weir, the guy who testified that there's so much value in this promise, concluded an annual value of $11.54 million. In other words, ConAgra has been charging a price premium to the tune of $11.54 million a year for the label, and because of the injunction, the full amount will accrue to the class. So according to Mr. Weir, this settlement is essentially minting money to the tune of 8 figures every year for the class. Despite ample opportunity, he's never tested his theory. The failure is more telling because he had a real-life example he could have examined. ConAgra dropped the 100% natural label years ago, so he could have studied whether that led to the removal of the price premium. Mr. Weir claims other real-life market factors made performing a post-labeling price check futile. But his admission appears to doom his own conclusion that led to a premium. If he cannot separate how other market factors to figure out a price, how can he do so in a hypothetical study he didn't conduct? So the Court of Appeals is burning the expert alive, and I'm loving every minute of it. They are burning Mr. Weir, the expert, to the ground. All right, so Mr. Weir says, okay, I conducted a hypothetical study, and in my hypothetical study, this was worth $11 million. And the court says, okay, but how about the real world? And Mr. Weir says, well, in the real world, I can't do this. It doesn't make any sense. So the Court of Appeals is like, okay, let me get this 100% straight. You have the perfect example for your case. The perfect example. This thing, which you're saying in a hypothetical is $11 million. But you have the perfect example. You can go do the numbers. You can go look at the data. And he says, but I can't do that, though. It's impossible. And the court's like, but if it's impossible, how did you come up with it hypothetically? Maybe you pulled the numbers out of your ass. So now, we next address and reject Appellee's argument that Erie precludes the application of Rule 23 to a class action settlement where state substantive law governs attorneys' fees in fee-shifting cases. Okay. So here's the deal. We've got a state law, and in the state law, there is, they say at least, a state substantive law that governs attorneys' fees in fee-shifting cases. Okay, great. Every year, tens of thousands of first-year law students learn about Erie versus Tompkins. We all do. And then soon after that, they become second and third-year law students with poor understandings of the doctrine. Some of these students take the bar exam, fail, and try to do other things. Others pass and become attorneys who still do not understand Erie. I feel personally called out now by the Court of Appeals. I feel attacked. We have passed the bar and we still do not understand Erie. I feel very, very attacked over here. That's very unfortunate. In any event, Henderson challenges settlement fairness under Rule 23 rather than the award of fees under 23H. Thus, Erie's effect on a fear-shifting law is simply not implicated because it's not being brought under the relevance. It's being brought under a collective class under the federal law, and so it doesn't matter about the state's shifting positions because, because the class is not state-specific, so no. Though some processes may suffice for political compromise and even most settlements, it does not for a class action settlement. Because they impose a binding judgment on absent class members, federal courts must approve class action settlements and ensure they're fair, reasonable, and adequate. And under the newly enacted federal rule, federal courts must scrutinize attorneys' fees for potential collusion that shortchanges the class. We therefore reverse and remand, and the attorneys may not be able to get the $6.8 million they were so helpful of. Very sad. Thus, that brings us to the end of the case of Robert Briseno versus Todd Henderson, our hero. In this case, Robert and a whole bunch of people sue over 15 cents for cooking oil. And the class representatives are going to get a little bit of money. And the attorneys certainly are. And one guy, our hero, objects. And the district court says, how about no? And the Court of Appeals says, how about yes? And then roasts literally everyone, including not just these attorneys, but all attorneys. They roasted all attorneys. I've been attacked. Also, they roasted Disney World, roasted Disney, and they roasted the Last Jedi, which was hilarious. And so, yeah, they have to go back and try again on the settlement, and good luck on that. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye. Though some process may suffer, no, that's not suffer, that's suffice. That's twice you've said it wrong, Kurt. It's not suffer. I know they start with the same letters, but they are different words. Try again.